Hey everybody, today I'm excited to tell you about a brand new case that just came down from the Massachusetts Supreme Court, Commonwealth versus Hallinan. Now that case dealt with older DUI cases, and more specifically those involving breathalyzer tests. Now you may be asking yourselves, how does this case apply to me? So I have a few questions for you. First, did you have a DUI case between June 1st, 2011 and April 18, 2019? Second, did you take a breathalyzer test in that case? And third, as a result of that breathalyzer test, did it cause you to either take a plea in the case or go to trial and lose that case and be convicted of that DUI? Now, if you answer yes to these questions, I have one more question for you. Do you want to overturn that old conviction? Now, if the answer to that question is yes, Commonwealth versus Hallinan just made it a hell of a lot easier to do so. Now, in the Hallinan case, they addressed the problems that were in existence at the Office of Alcohol Testing during that period of time, June 1st, 2011 through April 18, 2019. Now, if you don't know, the Office of Alcohol Testing is the state lab that calibrates and takes care of the breath test machines in Massachusetts. And as a result of all the problems up there, the court said that there was egregious government misconduct and that the breath tests during that period of time should not have been used. They should have been excluded from evidence. In other words, had you known about this stuff, it wouldn't have been used against you during that period of time. And so the court said that you should be able to file a motion for new trial regardless of whether you took a plea on the case and admitted to doing something or you went to trial and lost. And what they also said is that they made it a lot easier to do so. They've said that there already was egregious government misconduct and the evidence should not have been used against you, so that now all you have to show is that there was what they call a reasonable probability in the case of a plea that you wouldn't have taken the plea and admitted to doing it, or in the case of a trial, there's a reasonable probability that you wouldn't have been convicted. Now, what does this all mean? Essentially is that without the breath test, the evidence wasn't so strong against you, that the breath test itself is what caused you to either take the plea or lose at trial. And that so that if you can show this, then you can file a motion for a new trial, get the conviction overturned, and be granted a new trial. Now, at that new trial, they're not going to be able to use the breath test against you, which your case just got that much stronger. And quite frankly, in many cases, particularly these older cases, the DA's office may not even seek to re-prosecute the case, so your conviction may stay overturned forever. But what about the case where the DA's office does decide to re-prosecute you? At that case, like I said, the breath test is not going to come in evidence against you, and all they're going to have is the officer's observations and potentially other witness observations, which many times and in many cases, you can win at trial. But you might be asking yourselves, okay, well, if I go back to trial, there's no guarantees I could still lose again, and that's true. And the court in Hallinan addressed that case too. And what they said was that if you went back to trial and lost, that you could not get any worse sentence than you got the first time around, essentially because you've already done certain things, and they should take into account the classes you may have done if it's, say, a first offense, you did the alcohol education program, or probation you served, or any jail sentence you served. That should all be taken into account, but you couldn't be sentenced to anything worse than you got the first time around, including license suspension. This is what's really important to a lot of people, because they're like, well, if I go to trial and lose, is my license going to get resuspended? And the court in Hallinan said specifically, due to essentially double jeopardy concerns, that if you lost at the second trial, that your license would not be resuspended either. This is really important for a lot of people because it does affect their decision whether or not to even try this to overturn their earlier conviction. So the court in Hallinan made it a lot easier for people, made it a lot less risky for people to do so. And quite frankly, if you had an older conviction between June 1st, 2011 and April 18, 2019, and it involved a breathalyzer test, and you think that you either wouldn't have taken the plea or you wouldn't have lost at trial as a result, you should be speaking to a lawyer about filing a motion for a new trial and getting that off your record. Now, you may be asking yourselves, why is that important? And it's important because the thing about OUI or DUI in Massachusetts is it's cumulative throughout your lifetime. So even if you had a first offense maybe way back in your 20s, if you have additional offenses even much later on in time, what's going to happen is that you're going to get increasing penalties. A second offense or a third offense carry much greater penalties, and getting those off your record may be helpful for you in the future, whether it comes to job prospects or something else. If you have any questions about this, please feel free to give me a call or shoot me an email. If you got something out of this video, please feel free to like this video or subscribe to our channel. We'd really appreciate it.